afternoon. We want to bring you into the courtroom where a judge will sentence Michelle Carter for her role in her boyfriend's suicide, her boyfriend Conrad Roy.
Should there be any deviations from that, you will certainly hear a rapid and harsh response from this judge. So, Mr. Cataldo and Mr. Madeira, before we start this hearing, I wanted to alert you, I have here the ruling on Dr. Bregan's motion. I will file that. That'll be available to you in the clerk's office after this hearing. The second thing I wanted to bring to your attention is that I'm not sure you are aware that I think it was on Monday, I issued a sua sponte order impounding your sentencing memorandum. I was concerned that I may have misled you when I made my specific orders about the probation sentencing report, to think that your sentencing memorandum, even if filed with the clerk, would also be impounded. So before we get to the sentencing aspect of this case, do you wish to be heard on whether you want that report impounded? Ongoing.
1 minute, please.
Yes, of course.
Sure. You are watching the hearing going on inside Taunton District Court now as the judge speaks with lawyers before the victim impact statements begin. This is the sentencing of Michelle Carter, who was found guilty back in June. She's been free on bail ever since.
I will impose the same impoundment order as I have. I think on the other records was 10 years. I'll look that up, but I think the other records that we impounded were for 10 years as well.
I could be wrong, but my recollection was that it was a lifetime impoundment.
Oh, was it? Whatever it is, it will be the same. All right? Again, in an interest of trying to treat everyone with the same level of respect. All right. Okay, I have reviewed the probation sentencing report, which I am sure counsel has also reviewed. I've actually reviewed it several times. And before we start this hearing, I want to take this opportunity to thank Probation Officer Denise Taylor, the primary author of that report, as well as Assistant Chief Probation Officer Cheryl Beauregard, sitting to my right, for an outstanding report. That report was, to my reading, thorough, sensitive, intuitive, and highly professional. It was concise, especially given the amount of records to be reviewed, and to the point. Not only was it professional, but it also reflected a good understanding by both of these probation officers as to the statutory structure that governs this juvenile court. It has been an invaluable resource in my sentencing deliberations. All right, Commonwealth, I will hear from you. Do you wish to present any evidence, Commonwealth, or are you going to just go forward by representation?
Your Honor, with the court's permission, the Commonwealth would like to present 7 family members from the Roy family to read their impact statements, and which time I will read a final impact statement by Lynn Roy, Conrad's mother, and then offer our sentencing recommendation.
All right. Chapter 258B limits those who may present testimony as a victim witness. In this case, given that Mr. Roy, the actual victim in this case, is deceased, under 258B, Section 1, those who may speak are limited to, I wrote it down, in this case, the parents and the sibling, I think, are the only individuals who would be within that parameter of the definition. So those are the people who will be allowed to testify. So you may call the first one if you wish.
Your Honor, the Commonwealth would ask that Camden Roy take the stand, please.
All right. Ms. Camden Roy, please come up. And please remain standing for one moment while you are sworn.
Please raise your right hand. Just swear before the court, swear to tell the truth, full truth, and nothing but the truth, so help you God.
Good afternoon, Ms. Roy.
Good afternoon.
It's very, very important that you keep your voice up nice and loud, please, for my benefit as well as the benefit of everyone in the room. Please state your full name and spell your last name for the record.
I'm Camden Roy, R-O-Y.
Thank you, Ms. Roy. Ms. Roy, we're going to try to make this as easy for you as possible. Why don't you tell me what it is you would like me to know and to consider?
Should I just read?
You certainly can, yes.
Or not having that one person I've been with every day since birth, here and more is a pain that I will always
Louder, please.
that I'll always keep with me for the rest of my life. Not having my brother always going to be there for me, and knowing that will always haunt me. Knowing I'll never be an aunt to Conrad's children or get to see him getting married is something I never thought I would have to live with. He gave me an amazing 13 years, being my best friend and the best role model any little sister could ask for. Not a day goes by without him being my first thought waking up and my last thought going to bed. Throughout those 13 years with him, I have countless amazing memories that will always be with me. From stuffed animals fights in his bedroom, to him trying to teach me how to throw a football, catch a baseball, and shoot a basketball. To pick me up in his truck whenever I needed him. It's crazy to think that whenever I needed him, he was always there for me. But it's even crazier that now, whenever I need him, he'll never be there for me. And again. I wouldn't trade those short years I've had with him by my side for the world. I'll never get over this pain I feel every day, but I know that he loved me more than any big brother ever could.
Thank you very much. Is there anything you want to say beyond what you have read to me?
No, thank you.
All right, ma'am, then you may step down. Thank you very much. Do you have a further witness?
Thank you, Your Honor. Conrad Roy Jr., please.
All right. That is, as I understand it, the father of this child,
That's
correct?
correct,
Of this young man, pardon me. Good afternoon, sir. Please remain standing for one moment while you are sworn.
Please raise your right hand. Smack before the court, swear to tell the truth, full truth, and nothing but the truth, so help you God.
All right. Take a seat, sir. Make yourself comfortable. Please keep your voice up nice and loud. State your full name and spell your last name for the record.
Conrad Roy Jr., R-O-Y.
All right, sir. Do you wish to read or do you wish to speak to me directly? What would you like?
I wish to read.
Go right ahead.
I am Conrad Roy Jr. I am Conrad Roy III's father. I cannot begin to describe the despair I feel over the loss of my son. Perhaps I could ask you to imagine the worst emotional pain you have ever experienced and multiply it to an infinite number of times. I am heartbroken. Our family is heartbroken. My son was my best friend. Through the height of his depression, I was by his side trying to build his spirits and to affect his behavior positively, striving to lead him towards the bright future that was before him. As late as July 6, 2014, we were towing a fireworks barge back from Falmouth, and Coco drove the tugboat through the hurricane barrier by himself, with only the guide of a proud father watching over him. Coco was my first mate. In our future, I envisioned teaching him more skills and sharing my knowledge with him. Coco was sensitive, loving, intelligent, compassionate. He was a member of a supportive and wonderful family. His sisters adored him, and he was an excellent older brother. Although he did have some psychological troubles, we all felt that he was heading in the right direction and over the worst of it. And friends were critical to his emotional well-being. He had such a bright future. Michelle Carter exploited my son's weaknesses and used him as a pawn in her own well-being. She has not shown any remorse. The fact that my son was convinced to kill himself makes his death unimaginable. How could Michelle Carter behave so viciously and encourage my son to end his life? Where was her humanity? In what world is this behavior okay and acceptable? Coco is missed beyond measure. His family misses him, his sisters miss him, his friends miss him, and I miss him. The last words I said to my son was, "I love you." And Coco said, "I love you too." I miss him every moment of every day.
Thank you, sir. Is there anything you would like to add?
No, Your Honor.
Thank you very much. Ms. Flynn?
With the court's permission, I'd like to read the impact statement of Lynn Roy, Conrad's mother.
Certainly.
I do not know where to begin. When this became a news story, it completely overwhelmed myself, Conrad's dad, and our daughters. I have been doing my best to gain strength from Conrad's two sisters, and they gained strength watching me with doing my best to put one foot forward each and every day. It has been completely hard to be in certain social situations at times, feeling so broken. I have only been to a few court hearings, not that I didn't want to be there for my son, but I know that it's something that brings me more pain that I could not handle. I still cannot come to terms that another person who knew and described how much they loved my son would want to inflict so much pain on myself, his dad, his sisters, and all who loved him deeply. He is the most amazing human being and would have had a bright future. He should have been navigated into a positive direction. He certainly was with his support from his family. He accomplished more in his short life than some do in a lifetime. I know deep inside my soul, and I think often of my son's soul, and what a beautiful, selfless soul he was, that he would never want us to endure this pain with losing him. But what comes along at his court hearings is that he believed that social media was corrupting his generation. It is unfathomable to believe why someone would want such an amazing, young, caring man and everyone who loved him to carry this throughout the rest of our lives. There is not one day that I do not mourn the loss of my beloved son. Every day I strive to be a better mother to his sisters and a better person for him. I want him to be proud of me and how I am handling everything. I am trying to be there for his sisters in the best way that I can with all of my pain that we will carry with us until eternity. This does not stop after a trial. I pray that his death will save lives someday. I said to myself, in honor of Conrad, I need to handle this in the best, graceful way that I can. Conrad always wanted to help others. I cannot put into words what an honor it has been to be his mother. I am very blessed to have spent 18 years and 10 months with him. Every day I will continue to honor him. I pray that a law comes forth that another mother does not have to endure what I am. I thank everyone that has put their heart and soul into Conrad's life. They have been the voice when I cannot. I do not believe that another can go on to encourage someone to take their life, and it can be okay. My life will never be the same, nor his dad's, nor his sister. Camden and Morgan deserve so much more. Thank you, Your Honor.
Thank you very much, Ms. Flynn. So again, the statute provides any spouse, child, stepchild, sibling, parent, dependent, or legal guardian of Mr. Roy. Is there anyone else who falls within that category that you would like to present?
No, Your Honor.
All right. Are you to argue for the Commonwealth?
Yes, Your Honor.
And I will hear you.
Thank you. Your Honor, the Commonwealth is asking this court to impose a sentence of not less than 7, nor more than 12 years in state prison. Your Honor, as the evidence proved, the facts in this case are egregious. Your Honor read thousands of text messages and knows how the defendant undertook a deliberate, well-thought-out campaign to cause the death of Conrad Henry Roy, quite simply for her own personal gain and quest for attention. What a travesty. There is no earthly reason why Conrad Henry Roy should not be here today with his loving family, enjoying life, sharing his many gifts with the world, but he is not. And the reason he is not here is the defendant. Michelle Carter, her actions killed Conrad Roy. She ended his life to better her own. Now she has been convicted of a very serious crime, deserving of serious punishment. It is true that rehabilitation must be a part of any sentencing scheme. But in order to be rehabilitated, one must accept responsibility for their actions. To this date, the defendant has not accepted responsibility for Conrad's death. She has blamed it on his fragile mental state, his family situation, her right to free speech, or the medication that she was taking. She has shown no remorse, and in fact, after Conrad's death, it was quite the opposite. She sought attention and sympathy for herself. It wasn't enough that she took Lynn and Conrad Jr.'s only son, or Camden and Morgan Roy's older brother, or Tom Gamble's best friend. In the aftermath of Conrad's death, she continued to use and deceive all of them until she was caught by her own words. And I would submit to the court that had not the Fairhaven Police Department confronted her, she would have continued her charade as the grieving girlfriend, quite possibly forever. And I would ask you to recall one of the text messages she did send to Conrad, where she told him that she felt played and made a fool of by him because he hadn't killed himself yet. But after his death, she became the player. She manipulated and deceived his family into believing she tried her hardest to save him. She lied to the police about her role in his death. She failed to mention anything about what she did to her own parents or to her treating therapist. She duped the town of Plainville and the King Philip Regional High School when she brought Homers for Conrad to their community, collecting money as a way to bring awareness to suicide prevention, when in fact, she was the cause of Conrad's homicide. The defendant is asking this honorable court for probation, and the Commonwealth suggests that is just not a reasonable punishment for the death of Conrad Roy and the tremendous pain and suffering that she has inflicted upon his family, his friends, and the communities that both she and he lived in. Nor would probation serve to help her in any rehabilitation. The Commonwealth is aware that the court has many factors to consider when coming up with a sentence that is appropriate in this case. Some of those, of course, are the nature and circumstances and the seriousness of the offense. What can be more serious than the death of an 18-year-old, such a promising young man who will never walk the face of this earth again? The victim impact statements you heard from the family members of Conrad Roy. These two young girls will never have an older brother. Lynn and Conrad Jr. have lost their only son. She does not have a Board of Probation record. The Commonwealth concedes that. But another factor Your Honor must consider is the probation report, and I again, and the Commonwealth agrees, it was quite a telling report. Certain things that were important for the court to note and that the Commonwealth took note of was that the defendant had an inability to be honest with her therapist, and there was a lack of awareness in her parents about what she was up to, what her treatment was, and what they should do in order to improve in not only her health, but other things that were happening in her life. They simply didn't know. Another factor Your Honor could consider is a lack or a success or lack of past treatment. And again, the records bear out she was not benefiting, nor did she follow through with her treatment. Many times she was recommended to go on to do further things, and when things weren't going her way, she and her parents stopped treatment altogether. This is not someone that can stay in home confinement and get better, or even understand the ramifications of what she's done. And of course, we read through the letters from the defendant's memorandum. And again, the Commonwealth is concerned that her support system just does not get the impact of what she did. And I say that because of the terms that they used in their letters. They say things like, she made a mistake. She showed poor judgment. She didn't comprehend the severity of her situation. She was helping Conrad to achieve his goal. They don't seem to understand it was her plan. She was the one on the other end, goading him, telling him to get back into that car. She was the one that for weeks berated him. She never told any of them that, and even after his death, and even to this day. She says she didn't know how to call an adult for help. Your Honor, another consideration Your Honor would look to is the defendant's age. Now, this is a youthful offender, but she was 3 weeks away from her 18th birthday. We're not talking about some immature 14-year-old girl. We're talking about 17 and 3-week-old young woman who was involved in DECA, who was a very responsible student, who knew how to call the police because she said it to Sam Boardman. All I had to do was call the police, or even simpler than that, all I had to do was tell him that I loved him, and he would have gotten out of the car. But the Commonwealth suggests it's even simpler than that, and as Your Honor suggested and stated in your finding, all she had to do was say, get out of the car, get out of the truck, and none of us would be here right now. For all of these reasons, Your Honor, the Commonwealth respectfully asks this court to impose our recommendation. Thank you.
Flynn? Who speaks for the defendant?
No.
Mr. Cataldo, do you have any evidence to present?
No, Your Honor, other than the submission in the memorandum that you already have.
And I have read those.
Thank you.
Given them the same degree of attention that I did to the probation report. I would just say in passing, although certainly there has been no emotionalism, nor will there be in my determinations in this issue, that all of those letters, the letters of the Roy family, including those that I heard from today, and the other letters attached to Ms. Taylor's report, and the letters of Ms. Carter's family, give this court a fuller understanding of what these two young people were about. Go ahead, Mr. Cataldo.
Thank you very much, Your Honor. Your Honor, the defense is requesting, as you've seen in our sentencing memorandum for your consideration, a period of 5 years of supervised probation with various conditions, including mental health counseling, an evaluation, and following the recommendations to be supervised by probation of any and all mental health treatment that the evaluation comes back and recommends to this probation department, as well as having no contact with the Roys except as a pending lawsuit other than in connection with that. Your Honor, and the other conditions, whatever other conditions this court would deem fair and just and reasonable under the circumstances. Based upon the reasons, the background information gathered, and I won't go through the entire report, obviously, of the probation department and the sentencing memorandum submitted by the defense, Your Honor, I will summarize by saying, as this court is well aware, we're guided with the idea in the juvenile justice system that the goal is not punitive, but yet rehabilitative. Ms. Carter was 17 years old at the time. We have a body of law from both the United States Supreme Court as well as the SJC about the adolescent brain development which a court can consider on sentencing. And there is the clear body that says adolescents are not as culpable as full-grown adults. Ms. Carter does not, I suggest to this court, pose a danger to the public. I suggest that this sad, tragic manslaughter that she has now been convicted of was a very unusual set of circumstances unique to these two individuals, Conrad Roy and Michelle Carter, who are both struggling with mental health issues themselves. Ms. Carter, as this court has seen, both from the probation department's report as well as through the course of the trial, had her own issues. She had her own troubles dating back to the year, going back 3 or 4 years to 2011, where she was inpatient and treated for various eating disorders. And she was put on antidepressants back at that time, which she remained on these antidepressants until the year 2015. Ms. Carter grew up in Plainville, Massachusetts, lived her entire life here in Massachusetts in Plainville, went through the public school system, and graduated ultimately from King Philip School. All while the case was brought in 2015, she was able to graduate. Throughout the course of her history in the public school system, there is no evidence, and probation has verified that there are no records of any kind of disciplinary problems against Ms. Carter whatsoever. There's no criminal history, There's no involvement with the court system, delinquency. There's no involvement with DCF on Ms. Carter's, in her various growing up. She has had no criminal history whatsoever. I suggest, again, Your Honor, this was so unique, these two sad individuals taking these medications, and you saw the full texting respecting the court's decision of the conviction, but you saw the entire texting history and the evolution of the history. And I do think, just to touch upon that for a minute, there was an evolution of the history. The text messaging does not show that Michelle Carter just came up with some idea when they first started texting back in 2012 or 2013. Your Honor, Ms. Carter went on after high school. She did get accepted to college. She did not go to college as a result of the publicity connected with this particular prosecution. But during the time, she did further her education with online classes. She then took classes. She hopes to get involved in real estate and get a broker's license. She's been doing that. She was placed on strict conditions of her release back in 2015 when this case was pending. She has not violated any of those conditions of her release. Again, these are reasons why I suggest that she would be a successful candidate for probation and rehabilitative treatment in the community and not incarceration. Ms. Carter will have to live with the consequences of this for the rest of her life, with the publicity that this case has gained. That will be substantial. I think treatment is appropriate in this particular case for Ms. Carter. Your Honor, you have in the various documentation that she's still in counseling, verified by probation, that Ms. Gail Holmes opines that she's not a danger to the public, and specifically, as the court saw, that Ms. Carter does regret what happened. She also sent a letter to the probation department where she accepts responsibility for her actions, her words, her letter. The court has reviewed all this. Your Honor, I suggest that she is not a danger to the public, and in the remedial system, the juvenile system, probation is appropriate. Sadly, Ms. Carter herself was in treatment for nearly 4 or 5 years, but in particular, in considering what the just disposition of this case should be, Your Honor, I ask you to take particular attention to what transpired in June of 2014 to Ms. Carter. She did go back, and you have seen these records, that she did go back into McLean, or she did go into McLean Hospital inpatient, where the texting with Conrad Roy really escalated during this time. She was inpatient for bulimia. She had previously been anorexic. She was under taking SSRIs, taking antidepressant medication during this time. She is released from McLean in this critical time, and she begins counseling with Anchor Counseling. You've seen those records. She tells the counseling at Anchor, you've seen these records, that she was overwhelmed by her Conrad Roy's suicidal ideation. The fact that she did not do what ultimately this court has opined or stated that she should have done. I asked the court, however, to now, even though it did not absolve her from criminal responsibility, to factor that into its disposition, that she was going through some significant mental health issues herself. And during this time, prior to July 12th of 2014, Ms. Carter did get diagnosed with depressive disorder herself through the Anchor Counseling that she was involved in, Your Honor. You've also had the various character letters from many of the people who are here from the Carters, showing that she has a support group. Both family and friends submitted letters giving you the idea that this was out of character for Michelle Carter. This is not who Michelle Carter was. She was struggling at that time. And this is not the kind of behavior that had been exhibited in her prior history, nor is it something ever likely to happen again. She is now still in treatment. She is now off of any kind of medication, but she is treating with Gail Holmes, as you've seen and verified to the submissions that were given to this court. The fact that she has had no history with any juvenile court or any governmental bodies such as DCF, Your Honor, I think is very important in this case. In the totality of the circumstances, I think that she would be a successful candidate for probation, and there's nothing in the history that said that she would not abide by any of the conditions as laid out by this court. I don't think it's at all a long shot to say, well, we may give her a shot on probation, but I don't think she's going to make it. Her history dictates, I suggest to this court, that she would make it on probation with mental health treatment and counseling. For those reasons, Your Honor, we are asking, as I've laid out in detail in the memorandum, to give her an opportunity to show this court and the community as a whole that this was a horrible circumstance that she completely regrets and does, in her letter, take responsibility for, Your Honor. But it was at a point in time in her life, and sadly as well as Conrad Roy, that these two young individuals sadly came together and resulted in the tragic death of Conrad Roy. But I do think, given that this ultimately is a juvenile court, and given the body of science and the case law, that she is the kind of person that should be given a chance on probation to make it. And any and all conditions, as this court were to lay out, you can be sure that she would abide by those conditions. But this is a terrible, terrible tragedy. And she very much regrets this and prays Your Honor's judgment of leniency in this sad circumstance where she herself had mental health issues going on. Thank you very much, Your Honor.
Thank you very much. I'm going to take a recess until 10 minutes of 3 to reflect upon these cogent arguments made by both sides. I will be back at that time to render the decision. All rise.
So you've been looking live inside the courtroom in Taunton, where the judge has been listening to victim impact statements. This is the sentencing for Michelle Carter for the texting suicide death of Conrad Roy. The 20-year-old, the Carter is facing anywhere from probation to 20 years in prison. So far, the prosecution has requested a 7 to 12-year sentence. Her defense attorney argues that she should serve probation for what he called this terrible tragedy. We're going to take a break, and we will bring you the judge's decision and the judge's sentence for Michelle Carter, as the judge just mentioned, when he returns to the courtroom at about 10 minutes of 3. Bringing breaking news. We are bringing you live back inside the Taunton courtroom, where the judge is going to be reading the sentencing for 20-year-old Michelle Carter in the texting suicide death of Conrad Roy. This case, of course, became a national story with national attention. Just moments ago, the prosecution asked for a 7 to 12-year sentence. The defense asked for probation.
Section 58 of Chapter 119 requires that written findings be entered. I have done a draft of those findings, but I will do a final draft to incorporate the positions of the parties in this case and to reflect in that final decision on the impact of those arguments by Mr. Cataldo and Ms. Flynn. And of course, I had already read all of the letters that were reread to me here this afternoon, but certainly the effect of having them read to me by these people whose lives were so touched by Mr. Roy's passing was a consideration. I would say that those letters, those statements, the letters that accompanied Ms. Carter's sentencing memorandum, as I said earlier, gave a fuller understanding of both of these young people. But it also highlighted perhaps what has been the most poignant comment made by anyone in this trial, and that was by ADA Flynn, that this is a tragedy for two families. You need to understand, however, all of you, that this court has not, nor should it, allow any emotional response to this case to enter into its determinations in any way. Everyone is entitled to a decision devoid of any emotion with respect to this case. The relevant provisions of the law with respect to the juvenile court to this case are sections 53 and sections 58. Section 53 provides that notwithstanding the fact that, as Ms. Flynn so well pointed out, Ms. Carter was approximately 3 weeks away from what that law considers to be adulthood, she was still what Section 53 calls a child before the court. Section 53 says that children before the court charged with crimes are to be treated as children in need of aid, encouragement, and guidance. Section 53 preceded the youthful offender statute by many, many years. It is my opinion that Section 58 and the youthful offender statute, in fact, diluted somewhat the philosophy of Section 53, but the legislature, in its enactment of Section 58, the youthful offender statute, did not repeal Section 53. And so it is necessary that there be a balancing between the mandates of those two statutes. And that is what has guided this court. A comment on a few of the Section 58 considerations, and again, not to be misconstrued as the entire process or deliberative determinations. I have not found that Ms. Carter's age or level of maturity or even her mental illness have any significant impact on her actions. She was a bright young lady, did well in school, and I am satisfied that she was mindful of the actions for which she now stands convicted. So in my deliberations, that has had little weight. On the other hand, as Mr. Cataldo so well pointed out, I am aware of a huge body of law that has developed nationally and within this state, starting primarily with a case in 2012, Miller versus Alabama, and then picked up here in Massachusetts in the matter of Diachenko versus the district attorney, which is found at 466 Mass 655. Although Mr. Cataldo stated one side of it, it is my read of those cases that there is another side. And that is that even if the age and maturity level of the person at the time that they have committed the crime doesn't garner a great deal of significance, the fact that they are still of that young age offers a greater promise of rehabilitation. Now, I know that there has been some significant media coverage of this case. I assure you that I have steadfastly avoided any of that. It would not be proper, nor would I want to color any perceptions of my case by exposing myself to any of that. And I have not done so. But by the end of today, people will wonder why what has happened has happened. People may wonder why all of this has happened. If you really want to understand what we do in the juvenile court and how we come to the decisions that we make, it is all contained in this little pamphlet. This is a remarkable work that was issued by the Administrative Office of the Juvenile Court in April of 2016. It is the Dispositional and Sentencing Best Practices for Delinquent and Youthful Offender Matters. It came together by virtue of a committee that was chaired by an extremely knowledgeable judge, Judge Jay Blitzman, First Justice of Middlesex Juvenile Court, with several other highly knowledgeable juvenile court judges sitting on that same committee, as well as representatives from District Attorney's Office, CPCS, which represents the majority of children in the juvenile court, DYS, and many other agencies. When I first prepared my remarks for today, I took this book out and I started making purple marks on it and things that I would want to present to people to understand the context of what is going on. There were so many purple marks, I said I'm not going to do it. But if you really want to understand the juvenile court, read this document, because then you will understand what we are all about here. And as Mr. Cataldo said, we are the juvenile court, a unique and special aspect of the Massachusetts trial court. That document, Diachenko, Miller versus Alabama, all indicate that this court must and has considered a balancing between rehabilitation, the promise that that rehabilitation would work, and a punishment for the actions that have occurred. And so I have done so. Ms. Carter, please stand. Ms. Carter, a guilty finding having entered on the indictment charging you with the involuntary manslaughter of Conrad Roy III, now sentences you to 2.5 years in the Bristol County House of Correction. 15 months of said sentence shall be deemed a committed sentence, and the balance thereof shall be suspended until August 1st of 2022. You will be on probation, administrative, until you are released from incarceration, supervised thereafter, and the date of probation commences today. While you are on probation, there will be the usual conditions of probation, which include that you will obey all court orders and all local, state, and federal laws. You will report to your probation officer as that individual directs. You will allow the probation officer to visit in your home or school with or without notice. You will notify your probation officer within 48 hours if you change your residence, school, or employment. You will report to your probation officer within 48 hours after you are released from incarceration. You will not leave Massachusetts unless you get permission of your probation officer and sign a travel permit. You are required by virtue of your conviction to submit a DNA sample, and that will be done through the probation department. You will sign all releases as necessary for probation to verify your compliance with its terms, and you will pay all court-ordered fines, costs, and assessments. Those are the general terms. There are, in addition, specific terms. You are to have no contact with any member of the Roy family, excepting only that as may be necessary in conjunction with any civil litigation, including but not limited to the matter of estate of Conrad H. Roy III versus Michelle Carter, docket number 17-0846. You will have no contact, direct or indirect, with any of the civilian witnesses who testified at this trial, excepting only Dr. Bregan. This shall include, but not be limited to, Ms. Samantha Boardman, Ms. Alexandra Eblin, Ms. Ali Ethia, Ms. Olivia Mosoglo, and Thomas Gamble. Upon your release from incarceration, you shall present yourself within 48 hours to the Bristol County Juvenile Court Probation Department, Taunton Division, and thereafter shall follow all regulations as indicated by that probation department as to reporting requirements. When you report to probation, you will arrange through probation to schedule a mental health evaluation, which will be done by our juvenile court clinic. Said evaluation shall be for the purpose of addressing areas of need as to any mental health issues and to make recommendations for the treatment thereof. You will be required, as a condition of your probation, to cooperate with that evaluation and to follow those recommendations. A copy of the evaluation shall be provided to the probation department, but shall not be filed with the clerk's office. You shall also sign releases of information providing for any service provider from whom you are receiving services related to the mental health treatment to probation. allowing probation to receive information as to your attendance, the purpose and goals of your counseling, a general statement as to your cooperation with that service, and progress toward the stated goal. Said mental health services shall continue for as long as deemed necessary while you are on probation by the clinician or individual providing same. This court further orders, and this will be in writing, all of this is in writing, this court further orders that any disclosures made by Ms. Carter during the mental health evaluation or the treatment recommended may not be used in any substantive way at any subsequent evidentiary hearing that may occur relative to this matter to establish any of the elements of any crime, including this indictment, in the event that for whatever reason it is retried. Based upon this court's analysis, that to some degree, and drawing on Dr. Bregan's testimony, that he spoke in terms of behavior of grandiosity, and this court's assessment that for whatever reason, part of the motivation for this activity that led to your conviction was a sense of self-aggrandizement. This court now orders that you are not to profit from the events of which you now stand convicted and the facts surrounding same. For those counsel, I refer you to the case of Commonwealth versus Power, 42010, and the cases that are cited therein from 1995. You, Ms. Carter, your assignees, and any representatives acting on your authority are prohibited from directly or indirectly engaging in any profit or benefit-generating activity relating to the publication of facts or circumstances pertaining to your involvement in the criminal act for which you now stand convicted. This shall include contracting with any person, firm, corporation, partnership, association, or other legal entity with respect to the commission and/or the reenactment of the crime by way of a movie, book, magazine article, tape recording, recording of any type, radio, television, or internet presentation, interview, live entertainment of any kind, or from the expression of your thoughts, feelings, opinions, or emotions regarding such crime. Any action taken by you, whether by way of execution of a power of attorney, creation of corporate entities, or like, action to avoid compliance with this condition of probation, shall be considered a violation of the terms and conditions of your probation. As I noted, your probation shall be administrative until you are released from incarceration, and thereafter shall be supervised. The probation supervision fee is waived. A victim witness fee in the amount of $45 is imposed, and that shall be paid on or before September 11th of 2017. And finally, as I noted a moment ago, you will be required and must submit a DNA sample in accordance with General Laws, Chapter 22E. That is the sentence of the court. You may be seated. Mr. Cataldo, do you wish to be heard?
I do, Your Honor. May I approach?
You may. Thank you.
Your Honor, what I have just filed is a motion to stay the execution of the sentence.
All right, let me take a look at it, please.
Okay, thank you.
I'll hear you, sir.
Thank you very much, Your Honor. Your Honor, you have now reviewed the motion to stay the execution of the sentence. Your Honor, the issue is that not whether or not the defense, we need not establish that the appeal is more likely than not to be successful, but only that it presents an issue which is worthy of presentation to an appellate court one which offers some reasonable possibility of a successful decision on appeal. Your Honor, I have, this is not an exhaustive list by any means, but I refer the court back to the motion for required finding of not guilty for other issues that we presented during the course of the trial, as well as some issues that have been presented in the court's ultimate decision to find Ms. Carter guilty of involuntary manslaughter. I would argue to the court, and I do argue to the court, that this is a very unique and, despite the court's findings, novel issue involving speech alone, without presence, without physical presence. As the SJC even noted in their decision that went up pre-trial on a probable cause standard, they had never encountered a case where speech alone, where there wasn't physical presence, had come up before. I suggest that this is a fertile ground, a very important legal issue that needs to be pursued in the appellate courts for however long it takes to whatever court needs to address this very issue. There are many different issues involved in the appeal that will be coming. You have the Levesque issue, as the court noted, that she owed Conrad Roy a duty of care by a self-imposed created duty, while the judge yourself said that. We do take exception that the fire, if you will, was not created by Ms. Carter, but was created by Mr. Roy. That's another issue that we would be presenting to an appellate court. This court has already, and I won't go through each and every one of the motion for required finding, but I think this court is, it realizes that there are many issues in this trial and the uniqueness of a manslaughter without a statute for assisting suicide and the implications in the First Amendment that this case will have or could have once an appellate court ultimately rules on the First Amendment. So, Your Honor, the idea that even if the appellate court were to deny it, these are legitimate issues that are worthy of presentation, and it's something that the appellate court will ultimately may not rule on by the time Ms. Carter, if she is ordered to serve her sentence immediately, would already be out, would already be released. So for those reasons, Your Honor, we think that this court should issue a stay of the execution. She would be on probation immediately. She would have to do everything else and begin with all her conditions, but the incarceration portion could never be taken back if the court does not stay that particular issue. Further, Your Honor, as this court knows, in issuing whether or not, in deciding whether or not to issue a stay, is whether or not Ms. Carter might be a flight risk. I think that is extraordinarily minimal in this case, that she would be a flight risk. She's always appeared in court for the past 2 years while this case has been pending. She has not defaulted. She obeyed each and every term and condition of her pretrial release. I would suggest that she will go ahead and start with her probationary conditions, but just we're asking to stay the portion of the sentence that would dictate that she be incarcerated immediately. Your Honor, there are a lot of legal precedent, not just in Massachusetts, but from around the country, on the issues of whether or not speech without using true threats can be curtailed without a statute in place. These issues need to be litigated in an appellate court ultimately, and we're asking you, Your Honor, to stay the jail sentence until we can have that day in court in the appellate level of whichever court ultimately it goes to be the final arbiter determiner of the First Amendment, as well as the idea of the duty imposed on Michelle Carter and all the other issues on the motion for required finding of not guilty, some of which, Your Honor, were not presented on Commonwealth v. Carter, the SJC previously issued in 2016. There were some other issues, as this court notes. So for those reasons, I'm asking the court to stay the execution of the jail sentence of this case.
Mr. Cataldo, before you step away from the podium, sir, assuming I was to allow this motion, I have some concerns that extending a stay until the federal appeals are done might create two problems. And the first is that the statute seems to suggest that the stay ends when not the statute, the rule, pardon me, seems to suggest that the stay ends when the appeals court issues its rescript. So how would I be able to extend a stay beyond the issuance of a rescript by the Massachusetts Appellate or SJC? And then the second issue is, assuming that this wended its way through the federal court system, the date of August 1st, 2022 could have come and gone before Ms. Carter is required to serve her sentence in the event that ultimately my decision is upheld.
First question, Your Honor, on the rescript, I would suggest if a rescript were to come down and it is in Ms. Carter's favor, and secondly, if it came down against Ms. Carter's appeal on all the various issues, I would suggest, depending on which court, we would be asking that court at that time for a further stay.
Which I think begs my question of why, if I am to allow a stay, why should it not just be through the Massachusetts appellate court system? And then beyond that, you would have to obtain relief from the appellate level.
Well, I guess let me start by saying that is now my fallback position to this court. But I do think each and every level as we go up, and if it is ultimately denied by the SJC and there is a petition for cert or some other federal relief that we are looking for, then it would be incumbent upon the government move to terminate your stay at that time. But I think that the court should issue the stay and through all appellate procedure, but at least through the SJCs, and then if the court were to put the burden, if you will, for lack of a better word, over to the defense, I'm sure we'd be seeking it in a federal court. But if not, then I suggested it be on the government to then file for a revocation of the motion to stay.
Well, I think under the rule, clearly, once the rescript opinion issues, it is on them. But, and I suppose I should say at this point in time that although I have been very involved in this case, no one should assume that I have taken exclusive jurisdiction of it, all right, because I don't know how much longer I will be here. So in any event, please feel free to bring whatever concerns you have in front of any juvenile court judge. Thank you, Mr. Cataldo.
Thank you, Your Honor.
Ms. Flynn and Ms. Rayburn, do you wish to be heard?
Yes, Your Honor. Commonwealth vehemently would ask the court to deny the motion. The main issue in this case is that the defendant was convicted of involuntary manslaughter. This is not an assisted suicide case. This is not a First Amendment case. The SJC unanimously said that. There is no basis or likelihood of success for her appeal. This is a case that has been a 3-year ordeal for the Roy family. They deserve to have the sentence that you just handed down imposed today. And so the Commonwealth would suggest that this motion be denied.
All right. Thank you very much. I guess we have all come to know each other a little bit. I anticipated this motion, Mr. Cataldo, and I took some significant time to review the case of Commonwealth versus Hodge, which is found at 380 Mass 851. I note at page 855 of that decision they are talking about the significance of stays, even though the reporter's notes indicate that stays are not generally the practice here in Massachusetts. does say, however, that the practice of a stay is grounded in rudimentary notions of justice, that a person convicted of a crime who would a short sentence would otherwise be made nugatory in the case of a short sentence and would be impaired in the case of a larger sentence, and says further, citing Commonwealth v. Levin, 7 Mass. App. Court 501, the conviction may be reversible, but the time spent in prison is not. I am satisfied, under the Hodge language, that there is an issue worthy of presentation to the appellate court. In fact, this court believes that the wisdom of the appellate court will be of instruction now and going forward. And that's important. And one of the reasons it's important, Ms. Flynn and Ms. Rayburn, as the representatives of the Commonwealth of Massachusetts, and specifically the Roy family, is the letter of Mrs. Roy, who said that she hoped that the death of her son would result in law that could prevent this from ever happening again. I don't know what the appeals court will do. I don't know if it goes to the SJC, what the SJC will do. But I am satisfied that a grant of a stay through the Massachusetts court system only is warranted. This order will not encompass anything with respect to the federal system. Now, while Ms. Carter experiences the, apparently I have to file this. I'll give this to probation. I have the notice of the DNA. I will give that to probation to go over with Ms. Carter afterwards. All right, and let me give you that now before I forget. Thank you very much. Ms. Carter is going to be out on the stay, and she is going to be, under Rule 31, I have the authority to issue conditions, and that has been enhanced by the use of Chapter 276, Section, I'm sorry, wait a minute. To 76, Section 87. So Ms. Carter will be, although they call it pre-release on the form, it is obviously post-trial, but it applies. And there will be conditions which will track in large measure the conditions of probation. Violation of any of those conditions could result in the immediate revocation of the stay. And I have those written out. I just have to see if I can locate them amongst all my papers. Ms. Carrera, here are the, that's the motion for funds. You can distribute them to the lawyers, and you can give Mr. Cataldo and Mr. Madeira 2 copies so that they have it for the sake of, I believe there are 2 copies there. Okay? All right. I apparently must have left that other form on my desk. Do you have a copy? Is that on my copy? That's all right. I remember most of it. All right, that will be provided to the probation in about 5 minutes, Mr. Cataldo. But basically, it is the same existing conditions. No contact with the Roy family, no contact with the witnesses, no application for or obtaining of a passport, no leaving the Commonwealth of Massachusetts, and the language from Commonwealth versus Power are all incorporated in the 276-87 order that will enter. and probation will have that in 2 minutes. I must have just inadvertently left it on my desk upstairs. Is there anything further, Mr. Cataldo or Mr. Madeira?
We're all set. Thank you.
Commonwealth.
Your Honor, if I may
Yes.
request, given the court's ruling, if Your Honor can order an expedited assembly of the record. Usually that takes a week.
I'm happy to order that. I don't know, do you need a motion?
I may, Your Honor.
If you write it out and give it to the clerk, I'll make sure I endorse it before I leave today.
Absolutely.
But certainly that is allowed.
Could I do a handwritten motion, Your Honor, without the
That's fine. Just as long as I can read it. That's right. All right.
Yes, Your Honor, absolutely.
Anything further?
No, nothing further on behalf of the Commonwealth. Thank you.
All right. Ms. Carter, please wait to meet with probation. And we are adjourned. Thank you very much. All rise. Sue, I'll bring
So Michelle Carter will be out of prison for now on a stay. Judge Lawrence Moniz sentenced her to 2.5 years in prison, 15 months to be served with 5 years of probation with several conditions which he just detailed there, such as no contact with the Roy family, no leaving Massachusetts. Most importantly, he ordered that she may never, directly or indirectly, profit from this court case. Those conditions must be followed. But the defense attorney had argued that the unique circumstances of this case are so unusual. This will be important, fertile legal ground for the Massachusetts court system to explore whether someone can be guilty of a breach of encouraging someone to commit a homicide while not present. This is a freedom of speech issue, that because Michelle Carter was seen as encouraging Conrad Roy to take his own life, as the judge stipulated when he found her guilty in June, the most despicable part of her behavior, the judge felt, was that she encouraged Conrad Roy to get back into his truck after he had admitted that he had second thoughts about killing himself. The defense attorney argued that this will be very important fertile ground for freedom of speech issues moving forward. It's important to note that Judge Moniz said that the stay would be granted, the stay of the execution of her sentence, for now, only while this case winds its way through the Massachusetts court system. He trusts that the appellate court will take the totality of the case and agree with his findings, but that it would not extend to the federal court system. So at this point, of course, there is no knowing how long this might take, but if Michelle Carter had served the 15 months, which the judge ordered she must complete, of course, there's no taking that time served back. As the judge said in his finding, that convictions may be reversible, but time spent in prison is not. We will have thorough legal analysis of this fascinating case for you coming up on WBZ News at 5 o'clock. And of course, you can follow along on CBSBoston.com. Please join us at 5 o'clock. We'll see you then.